My lord, I beg to mention item number 11. My lord, the counsel for the respondent is out of station. So we need 3 weeks time. In the meantime, we'll file counter affidavit in opposition.
My lord, here I am appearing on behalf of the CBI, my lord. In fact, my lord, the bail, this application has been filed for cancellation of the bail by the CBI, my lord. So,
It is item number 11. No?
my lord.
You are basically appearing on behalf of
Adam Tatak.
standing counsel for CBI, and also heard Mr.
B. Kamdak.
Appearing on behalf of Mr.
A. Tatak.
For the respondent. Paid by an adjournment for 3 weeks. Stating that the this counsel is application and within the 3 weeks of time, they will be able to file the. You want to file the counter?
Yes.
Counter.
No.
Is the matter according after 3 weeks? It's the matter.
Most obliged.
Diplomat.
Your Lordship, I beg to mention item number 12. This matter may be adjourned for 2 weeks for filing one additional affidavit, Your Lordship. I'm for the petition. Item number 12.
No, name of the respondent is reflected in the court list, right?
Lordship.
Name of no counsel is reflected in the cause list.
Lordship, we have taken steps upon the respondents. But
This note dated 7/11/2023 reflects that you have not taken any steps on respond number 1 and 2.
Lordship,
Not yet, right?
we have taken steps upon respondent number 3, Your Lordship.
Why you left 1 and 2?
Lordship, respondent number 1 and 2, they are just performer party, Your Lordship. So,
But as you have added them as an respondents, you have to take steps. Right?
Lordship, I'll take steps, Your Lordship.
And
Anju.
Yes, and Anju, the Learning Council for the appellant. As per office note is at 7/11/2023. It is seen that steps are not being taken on respond number 1 and 2. And accordingly, the appellant is level to take steps on respond number 1 and 2, issuing notice. Register code and as usual process. Further, Ms. Anju has submitted that. You want to fill
Additional affidavit.
some more time is required to file the additional affidavit where allowed. The matter be according to the step after. We have to take steps on them, though we are listing it up to 4 weeks.
Lordship.
This-
All right.
Your Lordship, I beg to mention item number 15. May be listed after 1 week.
You are appealing on behalf of
Petitioner Rikeningo, main counsel is Rikeningo. He is not well today. He is main counsel here.
request made by the learning council for the respondent, appearing on behalf of. No, on the request made on behalf of learning council, Mr. R. India for the appellant, the petition, let the matter be listed accordingly. After you want,
Sorry,
you want 1 week?
1 week, yes.
After 1 week.
Motion.
Yes, ma'am. Well, I beg to mention item number 18.
Item number?
Item number 18.
Yes.
Matter may be adjourned for 3 months.
Huh?
Matter may be adjourned for 3 months.
Today,
Yes, ma'am. Then we will list after 3 months. Then we will list after 3 months.
after 3 weeks.
Yes. And the hearing for the responding. Key time.
So have you informed the appellant side?
Yes, ma'am.
3 weeks. Today.
Your lordship, I'm for the, I'd like to mention item number 16.
Item number?
16.
Yes, you need an adjournment. Why?
As the leading counsel is out of station, so
Is your leading counsel?
Vijay Jamu.
Huh?
Vijay Jamu.
Vijay Jamu.
Yeah. Madam, the matter may be fixed for Friday, for 2 days.
Request is made on behalf of and this council, Mr. Vijay Jamu, for the petition. For request of adjournment is made on behalf of the petition. Let the matter be listed. Yes, so he
Yes.
is out of station,
Yes, ma'am.
so it can be listed after 2 weeks?
Yes, on Friday.
Huh?
Friday. After
Friday? No
Then-
Friday.
Madam, Tuesday. Right, Tuesday.
You want to fix it on next Friday?
No, coming Friday. This Friday, after 2 days.
Yeah.
2 days.
After 2 days?
Day after
No, no.
tomorrow. And then Tuesday or Wednesday.
Tuesday will be 14th.
Yes.
14th. 14th.
Okay. Much obliged.
Joint application. Settlement option. All the parties, they have come to a settlement. Lordship, today at this juncture, Lordship, PP may call the CDR, Lordship. Yes,
So this is the joint petition.
joint application.
Petitioner number 1 is the accused or the informant?
He is the
Is the
victim.
accused, Lordship.
Rajendra.
1 is the victim,
2 is the
Oh,
victim.
2 is the victim.
2 is the victim, 1 is the,
3 is the informant, Lordship.
no, 1 is the victim.
No,
One
1
is-
is the accused, Lordship.
Accused. 2 and 3 are the victim and
Informant. 2 is the victim and 3 is the
they
informant.
have settled the matter.
Yeah, Lordship, I have annexed the settlement agreement. Lordship. It's at page 33, Lordship.
So what is the stage of the case at present?
Lordship, it is in evidence stage, but none of the witnesses they have deposed. Lordship.
Charge sheet, your lordship will find it page number 32. It was submitted in the year 2016. Your lordship.
FIR submitted in 2000? No, cases of 2016.
16.
Yes, charge sheet was also filed on 2016. So LCR may be called for in this case. At least to ascertain at what stage, if any,
You want to see?
the stage of the proceeding, your lordship, since it's very old case.
But as per your instruction, the evidence is not yet started.
Not yet started. Date is fixed for evidence, but not, none of them has deposed. It's fixed on January. Next date is on January.
This matter is of 2016, the charge sheet is of 2016. Why even after 5, 6, 7 years, no evidence is recorded? I don't know. So let us call for the case. So and so. This is a case under section so and so for washing of so and so. Issue notice, no formal notice is required to use it and previous forwarding this scan copy will be listed. The matter will be listed, it will has to come from which district?
LCR,
only,
Your Lordship.
Here only.
JMFC, here.
So one will be there or
On 24th of November, Your Lordship.
24th of
Scan copy.
24th of. Yes.
Different.
This
Item
also,
number-
Lordship, this item number 2, Lordship, this is
Also
also,
same cause of.
no, Lordship, this is a different matter.
Achha. Here also it is a joint petition,
A joint petition for quashing of FIR, Lordship.
not yet.
The matter is under investigation.
Still under investigation.
Under investigation. Lordship, offenses are 279, Lordship, that is non-bond, non-compoundable.
279/338.
338, Lordship. This 338 is compoundable. We have annexed the deed of settlement at page 20.
Is there any undertaking that you will provide the expenditure for the?
Lordship, it is stated in the deed of settlement, Lordship. In fact, we have paid around 250,000
Hmm.
as for medical expenses, Lordship. The injury caused to two victims, Lordship. We have paid 250,000. The
There were
accused,
two victims.
two victims were there. They were,
So number one, petition number one is the accused and 2 and 3 are the victims.
Lordship.
Out of 2 victims who lost the FIR,
Both of them, Lordship.
since 10/9/2023, the FIR was lost. Yes, please.
Yes, Your Lordship, I don't have any objection.
Discuss kar. Baat kar. Okay.
Reply. Your Lordship, my colleague, MS L. Hage, she's in traffic, Your Lordship. These matters are endorsed to her. If Your Lordship take up this matter after some time.
My lord.
Item number 4 and 5 also, Your Lordship, has been endorsed to her after some.
You want any adjournment 4 and 5 or what?
Possible.
5 you are referring and for 4 you are appearing.
Yes, ma'am. No,
You also-
giving notice is only way. He asked me to pass over the matter.
Sorry.
Item number 4, pass over the matter for some time.
For time being,
Yes, ma'am.
same.
4 and 5.
Public prosecution also, 4 and 5.
Sorry, I'm very mistake.
Your first.
Yes. Well, this matter is NDPS matter, Malad. Yeah, also, the accused was arrested. May I just take to the FIR? It's in page 14,
Page,
14. Yes, that was it. May I read?
no, it's okay, but the most probably the cases of commercial quantity.
Commercial quantity.
And since when he is in custody?
He has been since 5 month 22 days. You know, say
5 months.
5 and 22 days.
But,
So in this case, recovery also not been done from him. Just as per the investigation, as per the seizure, it also says, it's in page 15, it says there, it was recovered from the jungle. But then they say that recovery was on the basis of the statement of the one driver. But the driver is something different, driver was a different person, but then implicated on this accused person that In fact, the contraband was in his vehicle and it was driven by this accused. That was the only allegations. Whereas no contraband has been recovered from him.
No, from the vehicle it has been recovered.
Not from, even not from the vehicle, it from jungle, Your Lordship. So. And another also that, may I just take to the recovery memo and seizure memo. Even in the seizure memo and recovery memo also, countersign is done by magistrate. And then I'll just take to that's how this same was not seized on that day. I may just take to page 19. Here in annexure 3, in the last left side, it was countersigned by the magistrate, executive magistrate. His name is Hakum, Nailin Hakum. That is one. And another signature, I will just take. This was a seizure memo. And then seizure memo, I will just take to page 17. Page 17 also, in the bottom left side, it is executive magistrate Nailan Hakum. And Your Lordship may see the date. Date is on the top 17/5/2023. But then if I see this the siege document, the exhibit A is on page 21. Page 21, Your Lordship may see the counter sign of the magistrate. Date is same on 17, but then the magistrate signature is of a different person. It's in the right side. Executive magistrate. It was signed on date. It is mentioned 17/5/2000 is a page 21. Page 20.
Your Lordship will see that's the same district, but of different. One is
Page-
Kupa Hailuang and the other is Hailuang Anja.
So it is mentioned, the contraband was seized on 17/5/2023, but the countersign is of 18, and this is of a different magistrate. This also shows that the seizure and memo was not paper on the spot.
This thing is
Not able to-
things, but the question is that the matter is of commercial, so.
Your Lordship, in fact, in this matter, charge sheet has also been filed, Your Lordship.
Oh. Charge sheet is
And-
already filed.
Yes,
Yes, charge sheet.
Charge sheet has been
that's
filed.
part of that. But then
during the pendency of,
my prayer is that when the contraband is not recovered from him, and then there also a contradiction of seizure memo, recovery memo, and then exhibit A, which magistrate also seems to be a different. I want to just place some of the.
No, see, this now question is that definitely those things will come at the time of hearing or final hearing of the matter. But to grant the bail, I don't know, we'll see.
yes, Your Lordship, since the charge sheet has been already been filed, they can approach the trial court, Your Lordship. Also, with regard to the recovery, Your Lordship, it's with, Your Lordship will see, I have marked the statement of the accused. He was the one who have, in fact, shown them where he had thrown the opium at that point of when he had run from the Naka checking.
Thrown it back to the.
Yes,
their-
jungle, and he was the one who had helped the police in recovering those seized opiums.
That is the allegation, Your Lordship. But then thing is that there is a mandatory provision. If you see the NDPS seizure memo, recovery, and that has to be done on the spot. But in this case,
But the question is that there are some, they usually go by the section 37 of the NDPS. Then there are some satisfaction has to be there, or from the other side, it has to be from the prosecution side. So these are the something, some materials which has to be looked into while granting or during the bail application. So do you need any further? They have already filed
The charge
some
sheet.
charges.
Yes,
So
and in fact, Your Lordship, in the status report that I have submitted, Your Lordship, the accused was already in another case in Assam, and he was on bail when this case has happened, Your Lordship. He was already in bail at that point of time, Your Lordship. Now,
This is not the first case.
this is not the first case. During his bail conditions, when he was on bail, he has committed this offense again in the state, Your Lordship. Other than that, Lordship, for the bail application, Your Lordship, prima facie, there is enough material against the accused for consideration of not granting him bail, Your Lordship.
But then, if you see see the seizure memo, recovery memo is complete, it also can, prima facie, it shows that there's suspicions are there. He may be falsely implicated, that's what, and there is some of the affect judgment also is said, even the conviction was done, but then it was set aside on the ground of that, the seizure memo and then recovery memo, which was supposed to be prepared on the spot, that was not done. The mandatory provisions, because this is a grave, grave and serious offense. So they are supposed to follow the mandatory procedures. So that is the only the protection for the accused, especially in the NTPS matters. When this document clearly reflects that there is a lapses of the procedure. So could be my submission that it could be innocent. My place just one judgment which it says that the seizures memo has to be prepared on the spot. But what I observe, Lordship may say, but what I observe is seizure memo was not prepared on the spot. It was prepared maybe on the police station. And the magistrate who is signing the countersign also a different magistrate in the seizure memo and other documents. And Exhibit A, which is mentioned 17.5, whereas the magistrate is completely different, and then say the seizure memo is magistrate completely different. I'll just place one judgment which says that even if the mandatory provision is not complied, then on that grounds the accused was acquitted. This is 2020 volume 7, page 1492.
Which 2000?
Yes, 2020. Volume 12, page 492. The page, I will just read paragraph 6, 7, and 8. May I read paragraph 6, 7, and 8? Even if we were to assume that the anxiety of the investigating officers was to reach such and such place which was on the international border, therefore he did not have the time to record said information as per the requirement, section 42 of the Act. The matter doesn't rest there. There are other suspicious circumstances affecting the credibility of the prosecution. Though the investigating officer has stated that he had moved to such and such along with the team and 2 independent witnesses, the said independent witnesses were not examined. No explanation forthcoming on the count also. Apart from the material on record, it appears that no memos, that's important, no memos including the seizure memo were prepared at the spot, and all the papers were prepared on the reaching of the police station at the partner on such and such that the above, in our considered view, would affect the prosecution case with the vice of non-compliance of section 42 of the Act, the law laid down by the Constitution bench in such and such. Paragraph 8. On the aforesaid short ground alone, we are inclined to take the view that the appellant accused is entitled to acquittal, which we hereby order the conviction and sentence for the court below is set aside. Appeal is accordingly allowed. So this was on the ground of memo on except only mother. So let him face a trial and he can be released on the strict conditions. That's what I will pay for that.
Hard Mr. Esco. Hard Mr. Esco, the United Council for the petition, also heard. And STJ, the United Petition. This is an application at a section 20. Submitted for the United Council for the petition. That he is innocent and he has been falsely implicated in this case. More so, the case was behind the bars since last more than
More than 22 days.
more than 5 months. More than 5 months. The Learned Council further stressed on the seizure memo and the other documents wherein it shows that in seizure memo, the signature was made by one executive magistrate on 17/5/2023. But the same day, that is on 17/5/2023, another executive magistrate put his signature on the.
Your lordship will see that
Yeah,
this is just an exhibit, not any Caesar memo, your lordship.
No, not so,
It's-
the memo, this is an
Exhibit.
Ah.
And exhibit A is of the OPM or of the weighing machine. That's not mentioned anywhere in the exhibit, your lordship is.
No, this one 21 annexure, they annexure 4,
Yes,
the page 21, it is an
this
it
is
an
not,
exhibit.
yes, this is not a Caesar.
But if you signature in the another exhibit, we should put his signature on exhibit A on the same day. Thus from the accordingly it is submitted that the suspicion or doubt arises in regards to the genuineness of the Caesar memo, and from the above circumstances, it can be seen that the seizure was not made on the spot on the LSD level. In this context, we also relied on the decision of Honorable Apex Court reported in 2020 SC page 492 and mainly based on para 6, 7, and 8, wherein the Honorable Apex Court acquitted the accused as there was due to non-compliance of section 42 of the NDPS Act. Further submitted that the accused is innocent and further submitted that accused is still ready, but accused is ready and to appear each and every date of the hearing of this case, and there is no chance of accounting if the accused is allowed to go on bail. In this context, and as his unit learned additional people has submitted that there are sufficient implementing materials brought against the present accused petition accused, and from the statement made under section 151 CRPC by the witnesses, it is seen that this is the accused is the person who led the recovery of the contraband from the jungle, which was alleged to have been carried in his own vehicle. Further, she submitted that from the status report of the IO, it is no, so submitted that case has already been charged, and from the status report also, it is seen that the accused was also booked as in another case in Assam, and after obtaining bail from the same case, he again committed such kind of offense. Thus, this is not the first offense committed by the present accused. Accordingly, she raised objection in granting bail to the present accused petitioner at this stage. Next one, during the submission and the Learned Council for the research, I have also finished the status report and the diary, first scan copy of the case diary as submitted by the Learned Addiction GP. From the statement from the materials available in the case diary, saying that there were sufficient implementing materials found against the present accused, and considering the parenthesis materials, the case has also charged against him. There may be some discrepancies in the signatures by the learned executive magistrate, in exhibit as well as in seizure memos, but those matters will be considered at the final hearing of the case. Next paragraph. In a case of commercial quantity, for considerable bail application, the rigor of section 37 and the PS Act will follow, which speaks as the required. You just see the 37. During the instant case, it is in that not only there was an objection from the public prosecutor, but there is no reason to believe that the accused is innocent or he will not commit such kind of offense future, as from the status report of the status report submitted by the additional BP. It is seen that he has already committed same kind of offense, and this is the subsequent or second offense committed by the same person. In view of the above, considering what aspects of the case, we do not find it the case to allow the accused to go on bail at this case, according to the same statute. The petition statute. Now, you are going over by the putting the video. No, I want to you can do it. Your support.
Deeply.
Right.
May I please, my lord? My lord, this is criminal petition is filed under section 482 of CRPC for causing of FIR. Nahalagan PS case number 42/22, my lord. Here the my lord, accused and the victim, the complainant, they have jointly filed this criminal petition, my lord, since the matter has mutually settled outside of the court between the parties. And my lord, this allegation is tapped in dwelling house for tapped up two gas cylinder, two LPG gas cylinder.
Yes, later.
Yes, madam. So that has been recovered by the police and handed over to the complainant or owner of the property, madam. So now the matter mutually settled. So come before this honorable court for passing of the concerned PS case.
The stage of the case at present.
My lord. My lord, almost trial began and charge has been framed against the accused under section 380 and 457 IPC, my lord. And then now the stage speaks for evidence, my lord. But so far no evidence has been recorded, my lord, examined.
Scan copy of the LCR may be called for.
If you need, then we call for, if you don't need, then we call.
Lordship,
In the matter which he has submitted, that this was a case for theft of two gas cylinder.
Lordship.
Yes.
Victims were recovered and they came to an police settlement. But to see the other thing, if you want the case record, then
Also.
call for.
Lordship,
Want.
scan copy of the LCR.
My lord, my prayer is that, my lord, till calling of the LCR, so proceeding may be stayed, my lord.
Heard Mr. So and so, then counsel for the petition, also heard MS so and so, and this in a petition, section so and so, call for the scan copy of the SCR. Further considering the submission made by the another counsel for the petitioner, let the further proceeding be stayed till the time of conviction. Matter may be listed after, you want any fixed date or
Lordship, 2 weeks, Lordship.
after?
Okay.
Highly obliged, my lord.
Further proceeding be stayed. Was here. No news for. Year of time and then you again stuck on traffic.
Lordship, as he is saying, Lordship, his senior is on the way.
He is also on the way.
Yes, ma'am.
Practice. Five years.
Yes, sure. Yes.
It's the Navy.
Your lordship, this is an AB. For granting of free arrest bail to the applicant Charu Punya, your lordship. So your lordship, on the date 28/9/2023, interim was given, and this honorable court had directed the applicant to appear before the IO. So accordingly, he was appear before the IO, lordship. Then on 5/10/2023, again this matter has been taken up. So your lordship,
You were on interim fight order degree.
28/9/2023.
Okay,
Then your lordship,
again it was fixed on.
5/10/2000. Yes, your lordship. So your lordship, on that day,
Why it was
the,
not disposed of on that
pardon?
5/10, why it was not disposed of? On 5/10/2023, the CD was received,
Yes, your
but
lordship.
why it was not received? I mean disposed of.
On the ground that the case has not been completed.
Huh?
On that ground, the case has not been completed. On that ground, only this application has not been disposed.
Case not completed,
Yes, on that ground only, your lordship.
why? Case not completed means?
Lordship, last question, Lordship, the updated city was called for, Lordship, because this, that.
Fine.
Lordship,
Anyway, investigation
yes,
was.
Lordship, Lordship,
Now
the CD is
investigation is
there,
completed.
Lordship, yes, Lordship.
Yes.
Lordship, but the CD, Lordship, here I have gone to the CD where it is reflected that, the accused are not cooperating, Lordship. It is
Not
here,
cooperating.
yes, Lordship. It is reflected in this CD, Lordship. But they have already, Lordship, granted the interim protection, Lordship, to appear before the IO, Lordship. Then I have to, Lordship,
No, after the interim protection,
Lordship.
whether he appeared before the IO or not yet.
Lordship, as per this CD, Lordship, they have not appeared, Lordship.
We have already appeared, your lordship, even the bail bond was already been executed. On,
The Lordship, they have appeared, but they are not cooperating as the CD is saying that, Lordship. I don't know, Lordship,
So
why.
now see, question is if they appeared before the IO,
Lordship.
bond is also available.
Lordship, it is there, Lordship.
Then in that case, why his statement was not recorded?
Lordship, yeah, Lordship, CD is, then is, I'm submitting whatever is in CD, Lordship. So Lordship, this may fix tomorrow, Lordship, so that I'll inquire the matter all about the IO, Lordship, why this is, because in the record they have appeared, Lordship, and bail bond also been submitted. But why this is written that the accused are not cooperating till now?
We take instruction maybe
Lordship.
tomorrow.
Lordship.
much
Please
obliged.
tomorrow.
Alright.
Lordship, here, Lordship, before begin the Lordship, this matter, Lordship, here, Lordship, a little correction need to be needed. Last occasion, Lordship, I appeared, Lordship, this on the last order, Lordship, CD was called for, but this is BA, Lordship, bail application. The LCR should be called for, Lordship.
No, but BA means two kind of BA may be there. One is charge sheeted, one is not charge sheeted, which BA.
Here, Lordship, this is Lordship, under section Lordship 350 POCSO Lordship also there, Lordship.
No, I'm not in that.
Lordship.
Is BA, whether the case is charge sheeted BA or whether the case is not yet under investigation BA, what is?
Lordship, there is no charges done, Lordship.
Huh?
It
This
is,
not charge sheeted,
Lordship, it is Lordship, here, Lordship,
as per your instruction,
So far, I don't.
charge
have-
sheeted, Lordship, already.
case is charge sheet.
So far,
Yes
yes,
or not
my
recorded?
lord.
Lordship.
Yes. So now you want to call for the case
Yes,
diary
Lordship.
or? Huh?
Lordship, LCR Lordship. Because they is under
Now
custody
see,
Lordship.
here, with the question of LCR is what I'm saying.
Lordship.
Suppose if case is already charged, then this is cases with the,
Lordship.
under the special judge. So
Lordship.
then you can call for the LCR. But
Yes,
if
sir.
case is still under investigation, because he may be arrested during investigation, if it's still under investigation,
Lordship.
then CD will help you. So I don't know whether this case is charged or not it charged.
So far I have been informed that charge sheet has been submitted.
Charge sheet is already submitted.
But it is the oral information. So far I have not received in there.
So you want to call for the
Document.
LCR now?
Lordship.
Heard Mr. Sri Modi, the learning council for the petition, and also heard Ms. Kanhagi, the learning additional PP, appearing in the posted document. The case is fixed today for production of case diary, but it is submitted with the learned additional PP that inadvertently the case diary was called for in place of scan copy of the LCR as case has already been charged. Heard the scan copy of the case diary to call for accordingly. Let the matter be listed. Yes, any date?
Lordship. Next week, Lordship then.
Next week, any date?
Lordship.
15th is allowed. 16th?
16 November, Lordship.
16, 11.
16 is 16 November. Lordship. Okay.
Okay.
May it please your
Why
lordship.
case is fixed for order in order column?
Lordship, one IA is pending that is to be yet to be disposed of, my lord.
Oh, one I is pending.
Yes, lordship. It has been pending for long, my lord, because of the fact that the service has not been complete in respect of respond number 2. So finally,
you
my
are
lord,
doing
the
respond number
Yes, I am appearing for respondent number.
amicus curiae has been appointed, my lord.
two. So I is there, na?
Yes, my lord.
So this I is for bill.
Lordship, lordship.
Yes.
May I proceed, my lord? Lordship, the conviction has been under section 376.
Because I am so aware of the fact that you are.
Yes, my lord. Yes, my lord.
May I please, Lordship. Lordship, here the notice account of the private respondents are still awaited.
Private respondent, huh?
Yeah.
One. Then 3 is the government respondent or who? Number 3. One,
Of address your right.
1, 2.
Three.
No, as per the office note, 1, 2 and 4 are awaiting.
Awaited.
3 is already served.
Three,
I don't know, 3 is not reflected here.
not reflected.
Uh,
Maybe
one-
con-
acha,
maybe
unsub- unsub notice returned back.
Unsub.
Still
In respect of
number 3.
three laws.
Postal note, date address is not found.
Then,
So for 1, 2 and 4, it can be awaited.
yes,
And for 3, most probably you have to take rest.
resist.
Hard Mr.
Stay in.
Hard Mr. K. Dolan, the learning counsel for the petition. From the office note, dated 7/11/2023, it reveals that the notice returned unserved on respond number 3. And the notice, the service is still awaited for respond number 1, 2 and 4. Let the service be awaited for respondent number 1, 2 and 4. And press notice be issued on respondent number 3. The petitioner will take steps within 3 days. From the
Because, within 1 week, I need correct addresses.
Within 1 week. And, Let the matter be accordingly listed. The 4 weeks will be needed, I think, or 3 weeks, 4 weeks,
For 4 weeks.
after 4 weeks.
There is an interim order also.
Interim order was dated which day? Passed.
It was passed on 6/9/22.
6/9, the interim order be continued till next set of.
If you are right.
Okay. The respect of respond number 1 to 4.
Yes, my lord.
Service is already completed or?
Yes, my lord. Service is completed according to Office Note 18/8 in the month of August. My lord, it is prayed that this matter may be fixed for hearing. Because on 18/8, after 18/8, 3 months almost have passed. Here is also there.
This year is also going to see it. Your service was proper, na?
Yes, sir, the same address they provided in the reports, we have provided the same. As per the records. Your Honor. It has been received, the AD card is returned.
Yes, yes, as per office note also. Actually, who are the respondents? The respondents are actually,
The respondent number 1, Worship,
one is the
1 is my biological brother.
your biological brother.
Yes, Worship.
And
And
two?
respondent number 2 and 3 are my half brothers. My mother remarried, so through that marriage, they are there. And respondent number 4 is the daughter of respondent number 3. So we are family unit.
So they should appear before the court because I don't know what is the interest of their in that regard. But whatever.
That is
Anyway, they have their district. Part Mr.
Jitalula.
And this one has lost. And Mr. Jitanu, the Daniel Council for the petition. From the office note dated 18/8/2023. It is seen that the notices were duly served on this one number 1, 2, 3, and 4. But till 7/11/2023, no wakalatnama has been filed on behalf of the respondents. LCF has already been received. Accordingly, this is matter for final for hearing on unit.
It can be on Monday, Worship.
Monday, we were not sure. Monday, there is some problem is there Monday. I don't know, Mr. Choudhury, that's the maybe, maybe some may come. There is some sort of arrangement will be there. So not, don't skip it on Monday. 14 of the vote accident. 15 go paying. This will be listed on 15 on 15.
Much. Worship, there is an interim order.
Interim was there.
Yes.
Interim will continue till instead of.
Much.
My pleasure. Malad, this is the same matter day before yesterday, it was listed for listed today for Malad final disposal, but subject to Malad the convenience of the other party. Malad, here the precisely this application has been Malad criminal petition has been prepared for cancellation of the bail. Malad granted by the Lanet court
Today
below.
the other side is there. You are representing.
Yes. Is for the.
You are for the accused, other one.
Yes, I am for that.
So we can hear. Or is there any problem?
Madam.
No, we can hear item 4. Item 4 was very hearing.
Lordship.
Yes.
Lordship,
After
council is here, Lordship. Here, Lordship, only updated CD may be called for, Lordship. Because this is CD has arrived before the court vacation, Lordship. Now, Lordship, we require updated CD.
Will it be okay for you?
Yes, sir.
Only 2 days, Lordship, because it's another
Item
case.
number 4.
Item
Lordship.
four.
Item number 4, you write, heard Mr. N. What was that? Mr. N.
I'm B Padum. I'm for applicant B Padum. Item
The
number
applicant B.
Padum.
B, answer. Four, answer. B, pardon, the learned counsel for the petition also heard MS N. Hagi, the learned additional BP agreement, the opposite respondent and Mr. One for informant is another.
No, Lordship, it's not required, Lordship.
Informant is.
It's not necessary, Lordship.
Is there any other,
No, Lordship, there's no response, only PP is stated there, Lordship, PP.
but name of 4 advocates are shown in the call list. AK Singh, Takar Bangan, APP, L.
They appear for the complainant. On
Huh?
last occasion, they appear for the complainant.
Oh, that's what I'm saying.
Oh, Lordship, actually, yeah.
But can't appear on behalf of the respondent number 2. CD received, but it is submitted by the non CPP. So that the CD was received during the vacation and hence updated case diary will be called for. They are allowed. Later updated case diary will be called for. Let's sing on, yes.
Lordship, Monday or Tuesday, Lordship. 14, Lordship.
Tuesday.
Lordship, 14, Lordship.
Let's sing it on 14/11/2020.
In
Was
they
there the
continue. Interim order.
Interim was there?
Yes.
Interim will continue till next date of this.
Obliged.
My lord. May I have your lordship?
No, after 2.
It was listed today in item, it was item number 2, but could not,
No, I'm not taking the writ
it
petition.
is for orders.
I'm not taking the writ petitions.
Yes.
Division is there, no? So be the court number 1.
Yes, that court could not take up, my lord, because not before him, my lord. He was
Not
count,
before-
not before court number 1. It was directed not, without him, this matter may be listed to any other court. Because he
Then
could
you
not
have to
take,
wait, because most probably writ petitions, I'm not taking the writ petitions now.
yes,
So I cannot give you the permission because the registered judicial will accordingly give, because most probably there may be some reason why he is not taking the.
no, he could not take up because he was the counsel before.
Yes, that's what I'm saying. There may be some
Lordship
reason
was the,
for that.
yes,
But I cannot permit you here to list it matter tomorrow.
okay.
Talk with the registry people, registered judicial, if it can be possible, if this, because this bench is only taking up the
Only
criminal
for
matters
criminal.
as well as so and so.
Yes.
So, or otherwise next week it will be possible.
No, I came for this matter, my lord, that's why.
I cannot say, how can I give you permission? It's not with me, na? That's why I cannot say, because I'm not taking the writ
Writ
petitions
petition.
nowadays. These days, I'm not taking the writ petition. So I cannot give you any permission to take up the writ petition tomorrow by my court. You talk to registry people. they'll definitely say.
Apply.
May I Lordship? I beg to mention item number 17 and 19, Lordship. The leading counsel is out of station.
17?
17 and 19, Lordship.
Leading counsel, who is leading counsel?
R. Sonar.
R. Sona.
Yes, Lordship. Matter may be listed after 3 weeks.
For you, 17 and 19, na? Both for R. Sona. After 3 weeks,
Yes,
body
Lordship.
matters.
Yes. Much of that.
I'd like to mention item number 20, my lord. My lord, leading counsel M14 is out of station, my lord. This matter may be adjourned, my lord. Maybe
Why he is out of station? Yesterday also in 2-3 cases, most probably adjournment was paid for.
he was
What?
in emergency case, he was out of station. District,
Emergency?
yes,
Is there any health issues with him or any other personal matter?
a personal matter. maybe listed after 4 weeks, my lord.
Mr. M. Patel, Ilana Senior Constituency, list after 4 weeks.
Yes, my lord. Much obliged.
My lord, if I may, my lord, if I may, my lord, in item number 10, my lord, this
Item
morning,
number?
10.
Hmm.
My lord, the date had been fixed for 15th of November.
Yes,
Can it be kindly be fixed on 16, my lord?
I don't know what is the. No, 15, yes, I know, but
Yes,
mine it is also
it was.
15.
Yes, you know.
So can it
Could-
be 16? Can we inform other side?
It's ex parte, my lord.
Oh, your expert.
Ex parte,
Okay,
16.
okay, 16. Oh,
Much obliged.
who took the dictation? Huh? Who never said it? Okay. Yes, Miss Jenny, she's not here.
She's happy. She's just gone away. He'll come back. She'll come back. Until then, also I'll submit, advance my argument on merit.
On merit? or
Yes,
merit?
on merit now, on merit. I have already raised the issue of maintainability and I have placed some judgment. Now I will be coming to the merit of the case. My lord, this application has not been filed with clean hand, in fact. Because there is suppression of very material, a very important document. That is the court proceeding. Lordship may kindly see, my friend has already taken your lordship to the order passed by the learned special judge. Lordship, I have placed the order passed by the learned court below, before this honorable court, on this on earlier occasion. That must be there in the record. Lordship may kindly take up the order.
Earlier occasion.
Yes.
One order is we have placed most probably on 14/7/2020.
Yes, 47, 47 is here,
Then again,
10,
10/7.
10/7 is here.
Yes.
And finally, Lordship is ever, the bail was granted on 18/7. 18/7.
Yes.
So first, this bail application was moved before the special court on 10/7. We can read the order, Lordship.
Yes.
This application is taken up as unlisted today on being mentioned by Mr. Toda Adol Adol Council. The bail application is filed under section 439 of CRPC by one Sri Jumdo Doji, father of the accused Dorik Doji, with a prayer for granting bail to the accused son, who was arrested by the Alo police on 3/7/2023 in connection with Alo WPAS case number 11/2023 under section so and so. So this was taken up on 10/7 as a unlisted matter. And now Lordship come to the order passed on 14/7. So it transferred from the order that it was taken up on 10 as an unlisted matter and notice was issued to all the parties. Now let us come to the order passed on 14/7. Now this order will reveal the fact that notice was of course issued to the informant and the victim. Now may I read the order? 47 order. Mr. Nyokul, learned counsel for the applicant further, and Mrs. Angu, learned special PP for the state are present. This application is listed today for hearing. CD is placed before me. I have heard the learned counsel for the parties at length. The applicant father and the informant father are also present in person. Both the father of the applicant and the informant father was present at the time of hearing that was held on 14/7/2023. Now, Lordship, can infer from this order that notice was issued to the informant. That's why he was present on 47. So on 14/7, matter could not be disposed of, bail application could not be disposed of, and it was refixed on 18. Now, the presence of the informant or the victim on 18 non-presence, it is not vital in fact. Why is, my lord? Because the informant, they were aware that the next date fix is on 18. Lordship may kindly again look again into the order pass on 14, on the last portion, page number 2. List this matter for final hearing on 18/7/2023. So therefore, by referring to this order pass on 47, I am trying to convince your lordship that the applicant was, in fact, the informant was well aware of the fact that the matter is listed again on 18/7. So it was his choice only. He remained absent on that day, despite the notice that the matter is again being listed on 18. So he was given the opportunity, the submission advanced by the learned counsel for the petitioner before this court is in fact not true. I would say, saying that no notice was issued, no opportunity was given to them. It is not at all like that. They are given the opportunity. Your lordship has seen the order passed on 47. On 47, they were present. And on 47 itself, the next date was fixed. It was not that on 18/7, the matter was mentioned and taken up, and they were not heard. It is not a case like that. The date 18 was fixed on when this matter was taken up on 14. So the submission date, they were not this issued notice. It is in fact not convincing to me. And more so, my lord, in fact, the notice was issued to them. The applicant, he personally tried to serve the copy to the informant. After 10, when the matter is listed on 10/7 for the first time, notice was issued. I personally, I mean the applicant of that bail application, he personally went to the father of the victim and tried to serve the notice, but he refused to receive the
Who
notice.
authorizes him to serve personally notice?
In fact,
Is there any provision?
no, there is no provision, and more so, my lord, on 10, PP was there, special PP was there. This notice, of course, ought to have been served to the IO of the case. So this is not the fault of the applicant, of the accused, that notice was not served to the informant. It was the duty of the IO to serve the notice to the informant, because IO2 was aware, because since they were represented, state were represented by the special PP. So special PP might have, and it is obligatory on his part to disseminate the order passed by the Honorable Court. So if at all this notice could not be served to the informant, that is not the fault of the accused. It is the fault of the prosecution side. They ought to have served a notice on time. So now anyone, any case,
On 14th, they appear. It is not disputed. It is reflected in the order. This order also. Why this order has not been annexed in this application, present application? So I am on the very outset of my submission. I have submitted that the petitioner has not approached this honorable court with the
On 31st of October, there is an order of the note of the registry that we have
Sir.
taken steps on respond number
My
one.
lord, there was a only sole respondent. It's a criminal revision.
Respond number one, sole respondent,
Yes.
whatever. But there is no note subsequent, no notice there. Or service is still awaiting,
Yes, still awaited.
and LC has not been received. No?
Yes, ma'am.
Sole respondent was there.
Yes, sole respondent, criminal revision, civil revision.
Heard, Mr.
B. Kamdak.
We come to the Learned Council for the petition. From the office note dated 7/11/2023. It reveals that LC has not been received and service is also awaited for the sole respondent. Issue reminder to call for the LC and await for service on the sole respondent number one. Let the matter be accordingly listed after 3 weeks.
Yes, madam. My lord, there is an interim.
After 3 weeks, interim be continued till next date.
Deeply obliged.
My lord,
You ask me.
actually. Actually,
Your
Lordship,
name should be mentioned.
no, Lordship, actually, this matter was to be listed, but it was mentioned in the morning. It was, it was to be heard in the serial, but the opposite council, they had mentioned it.
Yeah.